live, yes.
Okay, good. Let me check on something. Okay, welcome everybody. We're gonna start in 5 seconds. All right, we're live and alive, which is a good thing. Lance Luke, Martin Pia here. Thank you guys for logging into our webinar Zoom platform. I see people still coming in. And then we're also broadcasting on social media, Facebook, LinkedIn, and YouTube. So thank you everybody for tuning in. Normally we have a topic that we give on something to do with buildings or construction or maybe real estate. This one is kind of real estate related, but although the topic is how not to be a slumlord, we're also going to cover how not to be a slum tenant. So we want equal opportunity here. So basically, we're going to be talking about legal tips and safe property management. Also, we're going to be talking about either if you're a tenant or a landlord or real estate agent, property manager, all this applies to you. I won't be getting into much talking about the law aspects of it, but just kind of covering general topics. And how did we get to this idea for the webinar? I've had people approach me with questions, either as a property manager or as a tenant. Most times it's tenants reaching out to our office asking about different things related to the building. You know, like, oh, my roof's leaking and I'm a tenant and it's been leaking for a while and the landlord doesn't seem to want to fix it or anything. So typical scenarios like that. Now let's go through. Oh, interesting. I gotta switch to my mouse here. Let me go through these slides real fast. I just realized that when I share screen on Zoom, my computer doesn't work to advance the slides. So this webinar is presented by Construction Management Inspection. And just to give you a background, I've been in property management since 1980. So although people may know me as a construction engineer or building expert, I'm also involved in real estate and property management. So I do have some background on this subject. So the purpose of the webinar today is understanding and meeting legal issues regarding landlord-tenant situations. We want to give priority to living conditions, make sure it's safe and sound and habitable, and preventing legal issues with informed ethical management. So we'll talk about more. So believe it or not, there's something called the Hawaii Residential Landlord Tenant Code, which is a law, and the law is very clear, and it not only applies to landlords, it also applies to tenants. And basically, there's provisions in the law that state who's supposed to do certain things. The landlord is supposed to do certain things. The tenant is supposed to do certain things, and so forth. So it's a lot of number of pages, and it keeps changing because of different things that happen or come up, you know, through the years. So do I know every single thing in that landlord tenant code? No. do most realtors or tenants know what's in there? No, not really, because things are changing and evolving all the time. Okay, so um, I want to make sure that we're talking about um, the law regarding single-family properties or duplexes or condominium or apartment units. This does not apply to commercial property. Like if you're a tenant and you lease out a retail store or uh, a warehouse, this does not apply. It also doesn't apply to if you're Airbnb or you're staying at a hotel or resort condo on a vacation rental for less than 6 months. This law does not apply. Okay, so if you're staying at a hotel and they don't fix stuff or that, you cannot cite this law. So let's move on. So legal obligations for landlords. Okay, the landlord's required to maintain a habitable property, providing essentials like utilities, water, plumbing, electric. Although the tenant may have to pay for these things, the landlord has to provide it. The landlord cannot rent a property where there's no electricity or no water, unless it's farmland and the main house has electricity, but the other houses don't, right? And you're not using it as a rental, you're using it as a storage or whatever. But the building code may allow it, although the landlord code may, not really comment on it. The other thing is that all the properties must meet structural and safety standards. So if you're a tenant, you cannot be living in a house where your stairs are ready to collapse or your front porch is so termite eaten and there's holes in it and you have a hard time walking, from the entrance to go to your house. So anything that's not right, not performing correctly, and it could be a building code violation, the landlord is required to fix. And there's nothing in the law that says if the landlord doesn't have time or doesn't have money, he doesn't have to fix it. Okay? It's the opposite. The law requires the landlord to fix these things. Now you may ask, well, is it clear? Is there a time limit? Yes, there is, but certain times um, the landlord may not be able to get hire workers in time because of the shortage, especially like during the pandemic. There are a lot of people that weren't working. It was hard to get contractors, and when you do hire a contractor, there's a supply chain problem, and we can't order lumber, so therefore we can't, fix this deck. And I tell them, well, just get something to make it safe in the meantime as a temporary fix, before the permanent fix. Okay, the next thing is landlords have to respect tenants' privacy. They can't be barging in without advance notice unless it's an emergency. So here's an example. If the tenant is not home and it's a high-rise condo and there's a report from management that water's coming outside the front door. They knock on the door, no one's there. Landlord tries to call the tenant, can't get a hold of the tenant for whatever reason. Only in those situations can the landlord enter the unit without the tenant's permission. Okay. Or you see smoke coming out of the window, knock on the door, no one's home. So these are emergency situations. If it's a non-emergency, the landlord cannot just go in anytime he wants to and look around, all that stuff. So the excuse may be, oh, I have to go in and look because, I want to see what things need to be repaired. Well, if that's the case, then you need to give the tenant proper notice to enter and go in and check. Now, as far as the tenant's requirement, the tenant is required to cooperate with the landlord or property manager. So in other words, if the property manager gives notice to the tenant, we need to inspect your place, and the tenant says, no, you're not coming in. I won't let you in. So that's not fair also, because if there's inspections that need to be done, maybe for repair or maintenance, that's valid reason to enter the property. Okay, so it goes both ways. And then the other thing is the landlord cannot engage in discriminatory practices when either renting the place out or even while the tenant's there, he cannot discriminate against the tenant. The tenant rights, okay? The tenant has a right, and this is remembered by law. The tenant has a right to expect that whatever property is being rented to him or her or a family, that the place is safe, sanitary, um, and it's follows the building code and the health requirements. So a tenant cannot move in and then all of a sudden call the landlord because there's a bunch of rats running around or roaches or something's breaking, roof's leaking or the plumbing's leaking or electrical. They turn on a light and they hear this buzzing sound and the light's blinking off and on. These are things that the landlord's obligated to fix. Now, where the tenant has been there a long time, years, 10 years, 15 years, and there's a report that the place is filled with roaches and rodents and all that, and the landlord says, well, the place was clean when the tenant moved in. The tenant just didn't take care of the place, and it's their fault that they don't clean, and that's why it's attracting roaches and rats and all that. So, it becomes an issue. He said, she said, and got to get to the bottom of it. I'll talk more about that later. The tenant has a right to expect fair treatment, and um, just because the tenant keeps calling about repairs to be made, that doesn't give the landlord or property manager excuse to ignore the tenant or say, hey, this guy's a crybaby all the time. He keeps making complaints all the time, for no reason. And our office gets calls also. And we're not really in the landlord tenant business. We deal with construction and buildings, but we get the call asking, oh, is this right? When I turn my light on, half the time it doesn't work, and the other time it just keeps blinking off and on. And we put in new bulbs, and we just think there's a problem. Okay, well, where do you live? How old is the house? Oh, the house was built in like the 40s. And so I asked them, well, do you know like where your electrical main circuit breaker box is? And they said, yeah. And then I said, well, take a look at it, take a picture, and then send it back to me. And when I get it back, I realized that it's a single family house, right? It's 900 square feet. And I look at the picture and there's only 4 circuit breakers. The house was built in 1932 or something like that. And so right away I say, well, I don't think the house was built to have all this electronics and appliances and all. So I just recommended that they let their property manager know to have an electrician come out, just, for safety. Whenever there's an electrical issue, we're always concerned because someone could get shocked or the house could burn down. If it's a plumbing thing, you might get flooded, right? But you're not going to get shocked and die from electrocution. Okay, the other issue is the tenant has rights for repair and maintenance. Okay, so I'll talk more about that as we go through. Trying to get my mouse to work here. It's acting like a rat. Okay, so common violations to avoid if you're a landlord. Now, if you're a tenant, pay attention to this too. Inadequate response to repair and maintenance requests, or inadequate, or I could throw in some other words, non-response or slow response. A tenant calls and it's like, okay, well, what's the problem now? Then you write it down and throw it in the folder as a non-action item, or we'll get to it because the property manager or landlord may feel that it's not a problem. Okay, so inadequate response, slow response, no response are all items. So if you're a tenant, just because you called once and nothing happens, don't let it go. Just call again, or write or email or text. There's different ways to communicate. Okay, and keep track. And if you feel that no one's paying attention to you, it may or may not be true. Maybe the property manager is trying to call a contractor, but they can't get a hold of one because they're all too busy. Uh, and or maybe they have to get permission from the owner of the property, because sometimes the property management agreement spells out the owner has to approve repairs to the property if any repairs are over $200. So the property manager now has to get a hold of the owner to get permission, to fix stuff. Now, in situations where it's an emergency, the proper protocol is the property manager notifies the owner and says, this is an emergency, we got to call a plumber. I don't know how much it's going to cost because I don't know what the problem is, or electrical or roof or structure repairs. Okay. The other thing you want to avoid as a landlord is when the tenant vacates, when they move out, you cannot hold on to their security deposit for longer than the prescribed time period. Okay. And if you do withhold money, let's say the tenant moved out and they didn't clean stuff, or you have to repaint because their kid used a magic marker and decided to draw stick figures on the kitchen wall, and you got to repaint. Okay, that's a valid expense that the tenant's responsible for. But you have to hire people to do the work, and then you have to supply the paid invoice to the tenant when you explain why you have to take money out of their security deposit. Okay. You can't just say, oh, you're not getting your deposit back because you left the place in a mess. So tough luck for you. Okay, that's illegal. Like I mentioned before, you can't enter, as a landlord, you can't enter the property without proper notice unless it's an emergency. Okay, so we're talking more about the landlord-tenant code, and basically those of you who are tuning in that are not from Hawaii, your state also has a landlord-tenant code. It may not be called the residential landlord-tenant code, and it's surely not called the Hawaii residential landlord-tenant code if you're in California, but every state has their own landlord-tenant laws. And and most of them are pretty much the same. You know, I looked at uh, the laws from California, New York, and other states, and most of them are similar. So Hawaii landlords can reference the full landlord tenant code, which is on the Hawaii DCCA website, the Department of Commerce and Consumer Affairs. You know who uses this landlord tenant code also is tenants. So the code is written for as a consumer protection to protect both landlords and tenants. Okay, it's not one-sided, but I can tell you case studies after. Steps to prevent hazards in rental properties. You want to be sure that things aren't or hazardous and health issues. And that's why if the property is uh, was constructed and built before 1977 or 78, you're required as a landlord or property manager to notify the tenant that uh, this property may contain lead-based paint. We don't know. We never had it tested, but this is just a heads up and give them information about lead-based paint. If you have it tested and there's none or there is, then you have to disclose that too. Quick response to repairs, you want to take action. I know a lot of times we get calls like, oh, you know, my water heater, I don't want hot water. Oh, okay. What did you do about it? Oh, I let my property manager know. Okay, so how long has this been going on? Oh, 3 weeks now. Like, oh, that doesn't, well, what's going on? Oh, well, they said it was gas, and because it was gas, that they had to call a different company, a plumbing company to come out and switch it, and they can't install a electrical one because there's not enough power in the house to power another large appliance. Okay, well, that makes sense. So just keep on it. Okay, routine inspections and maintenance. As a landlord or property manager, you want to be sure that uh, you just don't rent the house out or rent the property out and you don't check it for years and years, right? Um, you want to make sure that maybe every 6 months or every year you do an inspection, you fill out a report, and you send it to the property owner. Okay, so he knows you're on top of it. Likewise, if you're a tenant, you can do your own inspection, right? How about that? Tenants, do you have the inspection form that you can use? If not, you can find one online or use the same form that your property manager and landlord uses and fill out the form. That probably gives you an idea of you better not be too messy or clean your house and stuff. And here's a good idea. When you fill out the property inspection report, take pictures and add the photos to the report, right? Most people have cameras on their phones, right? Use that, have it printed or send an email out saying, oh, here's the things I noticed that may be a problem. If it's not a problem, but it's looking like it's turning into one, you can notify your landlord about it. And then when it does become a problem, they already had the heads up. Okay. Now, very important, addressing structural issues. You want to do your inspection to check these things out. And let's say that you're in a townhouse and you're not the only one using the stairs. So stairs to go up to the building, second floor, you may have 4 units or 8 units that share the same stairway. Now, if the wood is rotted out or the concrete's cracking, the railing's not safe, it's loose, notify your property manager or landlord. That's critical. Don't think that the other tenant's going to do that. It, it helps to address these things early so you can get it fixed. Common lawsuits over unsafe properties. I've been to court probably 50 times, okay, 50 on landlord tenant cases. And sometimes the tenant is liable and sometimes the landlord is. Most of those cases that I've been to court on were eviction cases where the tenant didn't pay rent and they needed to be kicked out. There's some where they didn't pay their rent because they're claiming that the landlord didn't fix stuff and they have to fix stuff on their own and they use the money. Instead of paying the landlord the rent money, they use the rent money to pay for the repairs. But it has to be documented in order for them to get credit, and it has to be proven, right? And there has to be notice. A tenant can't just say, oh, I'm not going to pay my rent because I'm going to use the money to fix the termite damage, and then they don't produce any repairs or anything. Okay. So one of the main issues is the habitability claims where the place has to be habitable, right? Which means that it has to be clean and code compliant so somebody can live there. If the tenant alleges that the property is unlivable due to health or safety standards, it has to be proven. Can it be proven? I'll give you an example. If there's mold growing on the wall because there was a plumbing leak or roof leak, that could be a cause of action. It doesn't matter if the mold is toxic or not, right? Now, in some cases, the mold's tested and it's toxic, and then the landlords is in worse shape, especially because they ignored the problem. Maybe there's a plumbing leak and they fix the plumbing, but the mold is still there. Okay, so there may be two issues, the plumbing and the mold issue. Or if there was a flood, right? So things have to be mitigated in order to be safe property. The claims of negligence, landlords ignore critical repairs, and the tenant notified them, my railing is loose and the wooden steps to go up to the house, I notice it's like wood rot and termite eaten. Can you please get it fixed? Okay, we're gonna try to find a handyman to do it. And weeks go by, months go by, and then next thing you know, as a property manager, you get the call. Oh, I'm at the doctor's office because remember the stairs I told you? Well, I fell through it and I got injured, and now I'm in the hospital. So that could turn into a big claim, right? A claim for personal injury due to premises liability issue. Okay, and it's hard to ignore these because you know what happens in cases like this? If the tenant hires an attorney, the attorney is going to hire an inspector as an expert witness. So let's say that I get the call as an expert. What is my job? My job is to go there, look at the condition of the property, and render an opinion as to, was this property, specifically the stairs and railing, was it built to code? Was it maintained? Was it in a proper state where it was safe? And if my answer was no, it wasn't, no, it was not safe, no, it didn't conform to the building code, yes, the railing was loose, yes, there was wood rot, yes, there was termite damage, it's not going to look good for the homeowner. And if it goes to court, what happens is the uh, insurance gets involved, right? And then the insurance hires their own adjuster or inspector to go out. But how can a insurance adjuster look at the same stairs and render a different opinion than what my opinion is, based on my professional credentials? So it's kind of a lost cause at that point. So what happens is the insurance company ends up settling the claim. Now, hopefully the person didn't get that hurt, but let's say if it's a situation where um, it's an elderly person and they got severely injured, the claim could be paying their medical, for the rest of their life. Or if it was a younger person and they got so injured that they couldn't work for the rest of their life, that's a huge multi-million-dollar claim. Okay, so landlords and property managers, heads up, do your inspections, follow up on repairs. A lot of property managers do, but some may be negligent. Common lawsuits over unsafe properties, mold, like I mentioned before. This is a big cause of legal action. Any kind of mold claim is scary because we don't really know what the situation is. In some cases, if it's a big situation, and I got hired to work on the case, I have to get testing done, and we have pages and pages of testing on the mold, right? And most people don't know how to read the reports because they're not uh, hygienists and uh, people who are, into the health issue and all that. The bottom line for me is the mold was there. Here's photos. The mold was toxic. Here's a report from the laboratory saying that the mold was toxic. That's it already. You can't argue with that. Faulty wiring. I mean, it's obvious if the light's flickering and you have buzzing noises in the circuit breaker and all that. Call an electrician, right? Take pictures of the wiring if you're a tenant so you can document it. And then lack of pest control. Rodents, they're after food, right? That's what they're looking for. So the cleanliness thing is important. Some more lawsuit issues. If you're guilty of neglect, beyond legal fees, landlords may face health department fines, repair costs, and harm to their reputation that could lower property values and increase vacancy rates. So you don't want to be known as the slumlord and don't rent from that guy. He never fixes anything. Although people might rent because it's cheap. Responding to tenant complaints effectively, communication is the key. Why? Because you need to accept when a tenant calls to report something, you need to document it, accept it, and then do something about it. Report back. Okay. Does your office have a protocol for requests? When a tenant calls in and makes a request to repair or fix something, what is the protocol? If it's in writing, that's the best. If it's not, oh, well, when we have time, we'll get to it. Well, how do you know whether it's something you need to take immediate action on or something that you can work on tomorrow, right? So if the tenant lived in a house for 10 years and he calls up and says, the house is not looking too nice. I think it needs to be, painted again. Okay, so that's something that can wait, right? But if the tenant calls and says, "Oh, every time I touch my light switch, I get this shock," that's something that you got to send an electrician out right away. Okay. And that's the timely response. You gotta decide, and it's common sense. You don't have to, one doesn't have to be a property manager with a real estate license and trained in property management to know or to use common sense to determine what cause of action to take, whether you can wait on something or not. Immediate attention to emergency complaints, well, that's a must, right? Let's talk about evictions. There's eviction laws in Hawaii. Of course, most evictions are because non-payment of rent, and there's a 5-day notice that needs to be given. Also, eviction can be done citing a violation of lease terms, such as when the landlord rented to you, it was only to you as a tenant. You decided to sublet, which is you decided to get a roommate without asking the landlord. Okay, so why do you think it's a problem? Well, if you ask the landlord saying, well, we don't know who this person is. We need to qualify every potential tenant. So they got to fill out a form, and we got to know where they work, how much money they make, and all that to see if they can afford the rent. What is their past history? And when the tenant decides to bring in a roommate, we don't know who this person is. Plus that it's a violation of the lease term because the the main tenant wasn't allowed to rent out to other people. Okay, so that's normally there's no eviction. The landlord doesn't evict for that, but there's cases where they have loud parties and they don't take care of the place. And then the landlord finds out that, there's two other tenants in the property. They've been living there for 6 months and he never gave them permission. And then the other thing is the new nuisance behavior that it disrupts other tenants or other neighbors, where they have loud parties or they're parking their cars in other people's parking stalls, or they're just leaving bags of rubbish outside the trash can and not throwing it in the trash bin. All these things, or uh, setting up. I mean, there's could be a yard area where they decide to take over the common area and put picnic tables and stuff, and it's only for their use and not for other tenants, and that's not allowed either. So remember, as a landlord, if the tenant doesn't pay rent or doesn't follow the rules, there's certain criteria that you have to follow. You don't want to do what's called unlawful actions or self-help eviction. The self-help is, instead of hiring an attorney or somebody to help you with the eviction action, you decide to take it on your own. Why should I pay an attorney? I'll just go change the locks. These guys never pay rent for, over 2 months, 3 months now. I'm just going to change the lock so they can't go in. Or you know what? I'm just going to shut off their electricity and water, right? And teach them a lesson. Those things are illegal in Hawaii. Landlords cannot do that. I don't care how many months the tenant didn't pay rent. You cannot just change the locks and lock the tenant out, and you cannot cut off their utilities. You're going to get in big trouble. If you go to court and the landlord makes a claim that that's what you did, it's called a retaliatory eviction. You're the one that's going to be in trouble. And you can say that the tenant owes you $20,000 in back rent, and the judge is just going to say, yeah, that's fine, but what you did was illegal. Okay, so the evictions must follow the due process of the law, and retaliation is not a good thing. What's worse is the tenant keeps calling. Okay, let's say that the tenant's been there for a year, and then he keeps calling and reporting complaints, and the property manager goes, you live in a apartment building. You're the only one that complains. So none of the other tenants are complaining. And then right after that, you get a letter saying your rent is going to be increased, $200 a month. And they didn't increase any of the other tenants. Okay, that's discrimination, that's retaliation. And if the reason is, oh, well, we increase the rent because we want to keep this tenant out because they complain too much, that's against the law. You cannot do that as a landlord or property manager. If you're going to raise the rent, you got to raise everybody's rent so it doesn't look like you're singling out, one person. Unless now that tenant's been there, for a long time, and his or her rent is way lower than the other tenants. Then you can say, well, you increase the rent up to, market rent to match the other tenants. Okay, but the timing is critical, because if you do that after the tenant made complaints about fixing stuff, it's not going to look good. So timing is critical. Step-by-step eviction process. As a landlord, you got to provide written notice to vacate with clear reasons. Now, if a tenant is on a fixed lease, and this applies to tenants also, if a tenant is on a fixed lease, and let's say the fixed lease ends at the end of February, okay, the law doesn't require you to give written notice to the tenant saying where you have to move out. It's clear, but common sense dictates that probably in November, December, you should send the tenant a notice saying, by the way, we're not gonna renew your lease, so you're gonna have to move out when your lease ends. Don't not communicate, make it clear, because what happens is if the tenant gets caught off guard, they weren't preparing, they're not going to move out when you think they are, right? And likewise, if you're a tenant and you know your lease is ending, communicate with the landlord or property manager asking, oh, can I get a renewal for another 6 months or a year? Don't just say nothing and then both sides, the landlord expects you to move out and you don't think you need to move out, and by saying he never got any notice to move out, right? Your notice is already on your rental agreement that your lease ends on this date, and that's when you're supposed to move out. Okay. Also, eviction process. The landlord cannot just go to your house, knock on the door, and say, move out. Well, they could, but that's not legal. It has to be written notice. And if the tenant doesn't move out, they have to go to court and file the necessary papers. If the tenant doesn't move out on his own, doesn't voluntarily move out. Okay. There's no such thing as do your own eviction. Okay, it has to be done through the courts. Allowing court enforcement if the tenant refused to vacate after a court ruling. So let's say you do go to court and the adjudication is, yes, the tenant didn't pay rent, and the judge says, yes, the tenant got to move out by this date. Okay, if the tenant doesn't move out, you still got to go back to court and let the court know the tenant didn't move out, and whatever action the court's going to decide that needs to be done. So both sides, the landlord and tenants, need to know that this is what the process is. Alternatives to eviction. A lot of times it's a court action and the judge says, you guys go outside and mediate. What does that mean? Well, there's a third party person that understands the situation, and it's an alternative. So the mediation is both sides either go outside the courtroom and talk in a separate mediation or meeting office, or there's several mediation centers. There's a Hawaii Mediation Center that you can go to and try to resolve your disputes out of court, which can save a lot of aggravation. So a lot of times that helps. Sometimes it doesn't because it's too far gone and both parties aren't agreeing to anything. So then you go back to court and let the judge decide. Importance of documentation. You want to document repairs and upkeep, and you also want to document inquiries or calls or letters regarding fixing things. Okay. You have to have a paper trail, because if you go to court and the tenant claims that they notified you 6 months ago and you still didn't fix the bad electrical or the plumbing problem, you have your documentation, or if you don't, the tenant will have, right? Hopefully. Types of records to keep: maintenance and repair logs, tenant communication logs, and tenant communication can be, if the tenant made a phone call and called the office, you want to document that. The tenant sends an email, okay? Print it out, put it in the file. If the tenant sends a text, print it out, put it in the file. You want to keep all these records. Now, if the tenant called once and then goes to court or complains that they called you, 20 times, did they email you? Did they text? You want to have a record of that. Then you can say, no, the tenant didn't write any letter or anything. And then when you have repairs done, you want to keep the receipts. You want to keep the paid invoices from the contractors to prove that work was done and what work. A lot of property managers use software programs, property management software that can generate maintenance reminders and store records and all that. So that's a good thing. You don't need it if you're managing only a couple properties. Effective documentation includes date and time the tenant reported, what the nature of the issue is, date repairs were completed, who performed the repairs, any follow-up action needed that needs to be taken. So when I used to manage property, after the repair was done, I would call the tenant up and say, just checking in, is your plumbing working okay? How's your electrical? Did they fix the roof right? And then document that. So you have that in writing. Because if the tenant says, they came to fix it, but it's still not fixed, right? Then you can have the document of the telephone call saying that he called and spoke to the tenant said everything was okay. What's the conclusion? The conclusion is both sides, landlord or tenant, has to do their job, maintain the property, keep the property in good working order, keep it safe. If you're a tenant, your job is not to fix stuff in the property. Your job is to let the landlord or property management know that things need to be fixed. Okay. And the landlord or property manager's job is to fix stuff, get things repaired and not take too long. What you miss, we've given a lot of other webinars in building, construction, real estate. You can go to our website. What's coming up? We have a whole list of other topics coming up, and I got some interesting ones coming up, like what is an expert witness, painting and waterproofing, vents, lead pipes, cesspool. All that's coming up in the future. Want to remind you that our website is askbuildingexpert.now.site, that you can go and watch previous webinars we've given. We also have expert websites on each different topic, painting, asphalt, concrete repair. We also have blogs on our website, and then the list of webinars listed from several years ago we started this, so we have a lot of webinars, over 80, I think, lost track. Then we have books that I wrote that you can look at whatever topic you want. Some of them are free, but all of them are on Amazon if you are interested in buying. It gives Martin and I lunch money. We have websites. Okay, one is tenantrights.now.site, premises liability.now.site. The tenant rights is a site not for landlords but for tenants. What rights do you have as a tenant? And I got pictures of bad things, holes in the ceiling from rats, and unsafe stairs and things like that, just to give you a good idea. So I know I breezed through this. You got questions, we got answers. Now's the time. If you're on social media, post your question. If you post it and we don't get to it, I'll respond as soon as I can. And if you're on our Zoom platform, we welcome you to post your question on the chat feature or the Q&A. So, Martin, we got any comments or questions?
Yes, Lance, we do. A couple of them, and good questions. Besides all the good information you provided, the first one I have here is, what are some proactive steps landlords can take to maintain open communication and build trust with tenants? That's the essence of the whole session today.
Well, the main issue is communicate. Keep the communication lines open, and don't just collect rent every month and not communicate with the tenant. I know there's a tendency to just not hear from the tenant, and okay, good, we'll just collect the rent. But once in a while, check in, see how everything's going, because you never know. When I used to manage property, I used to randomly call tenants up, and it's interesting because the tenant says, "Oh, I'm glad you called because I was wondering when someone's gonna come fix my disposal." And I'm like, "Oh, I didn't know about it. Did you call?" "Oh yeah, I called like 6 months ago and no one no one came." So we'll go back and look at our record. Sure enough, there was a call logged in and no one followed up on it. So you want to make sure that the tenant feels that people are listening and following up, right? And if you can't get somebody to fix something, let the tenant know, hey, sorry, trying to get some contractors lined up, or I got this contractor we hired, but they're too busy. They can't come until next week, or whatever situation is. Let them know. Uh, hold on a second, Martin.
Yes,
I
sir.
just got like I gotta plug my power cord in on my laptop. But while I'm doing that, can you ask the next question?
I sure can. And here it is. Hopefully you can hear all right. Can you
Yeah.
share an example of a common oversight in property maintenance that often leads to legal issues and how to prevent it?
Okay. Um, hold on. I'm trying to find my cord here.
Make sure you get your power
Sorry.
so I don't lose you.
Yeah, I got it now. Okay. Sorry. What was the question again?
No problem. It says, can you share an example of a common oversight in property maintenance that often leads to legal issues and how to prevent it, based on your
Okay.
many years of experience as the expert witness?
Um, the key is you can't like ignore the problem. Okay, so um, if things aren't fixed and it can be proven that it's a health or safety issue or structural problem, that's a big no-no. If the tenant gets so upset that nothing's being done and they take the landlord to court, it's already a losing battle already. Uh, just the fact that you got to spend time going to court to deal with the problem. So that that to me is something that the landlords need to follow up on so you're not faced with this aggravation and expense because you're going to have to hire an attorney to represent you. And there's one situation that happened. The tenant didn't pay rent, and they sent letters saying, "I'm not paying my rent until you guys fix all these things." And they gave a whole list. It was 2 pages long, and the property manager said, "Hey, they cannot be doing that to us, threatening us that they're not going to pay rent." And so they sent a letter back saying, "You still have to pay your rent. When you pay your rent, then we'll fix these things." And the tenant sent a letter back saying, "That's not how it works. You have to you have to fix these things, otherwise I'm going to fix it." So what happened was the tenant sent in receipts showing that they actually hired somebody on their own to fix stuff, and they used their rent money for that. So in court, it was kind of crazy because the judge looked at it and said, "Well, you guys, landlord, you guys didn't fix these stuff, so the tenant fixed it on his own. You're lucky that the tenant wanted to fix it. So all the money that the tenant spent uh fixing all these things, we're deducting it from the rent." So the landlord side thought they had a big issue because they said, we're following the law. The tenant's still obligated to pay rent, but the judge sided with the tenant. Now, most of the times when I went to court, even if the tenant was wrong, the court still sided with the tenant. So when I get the property managers and landlords calling me saying, we have a strong case here, and I'm going, well, that's in your opinion. When you go to court, you don't know. The judge could have been tired, didn't have enough sleep, and because of the homeless situation we have in Hawaii, a lot of the courts, the judges are signing with the tenant. They don't want the tenant to be evicted, so they give the tenant chance. Oh, go back and mediate, or I said, how much rent can you pay? The tenant owes $20,000, and the tenant says, "Oh, I can only pay 2,000." So the judge tells the landlord, "All right, go accept the $2,000, and then you guys go work on an agreement." So the tenant can't. Sometimes I'm like shocked at what the court's response is, and that's why it's not a slam dunk. If you think that you have a good case, you go to court, it may not end up the way that you want it. So
Very good. We have one more question here if you get time for it. Let me
yeah.
see. Okay, it says, what are the key records landlords should keep to protect themselves legally, especially if tenant complaints escalate?
Always have a paper trail. The tenant makes a call, document it. The tenant sends you a letter, put it in the file, follow up on it, email, text, any kind of form of communication, right? You wanna save it, and that's gonna be your protection. If you have things fixed, keep your invoices, keep your paid invoices, keep the contractor's proposal or whatever, even if it's handwritten. I've had situations where the tenant paid their rent in an envelope with a letter saying, "Here's my rent," and they put a sticky note on it. "Oh, by the way, uh, the toilet is leaking, right? Put it in the file because when there's a flood or no follow-up, the tenant's gonna say, "Oh, I sent you the thing, right?" And if you don't have it, you're gonna say, "Well, no, you didn't," right? And this time, the tenant actually made a copy of it, and it went to court because uh, the landlord accused the tenant of breaking the toilet and causing the flood. But then the tenant had a copy of the rent check with the post-it note that he said, and that's sufficient notice. The tenant doesn't have to write a formal letter, "Dear landlord, by the way, my toilet is leaking. Can you please fix it?" A post-it note is valid communication. So that's uh, that's a little takeaway on that. Any other comments or questions? I know we're out of time.
Well, I just had one question. There's no more right now, but you mentioned about the legal process and how it seems to, in some cases, I guess it's a case by case thing where they lean towards the tenants. I was just wondering, if that's your experience, but in some of these more complex things where they got to go back and forth, or to the judge says go do this and that. I mean, that can really prolong the process, yeah, whether it's an eviction. So is the process fast enough to really take care of the
No,
situations?
no, the process is very slow. And let me give you a heads up. The court doesn't like to hear these kind of cases. So they're already upset. They're upset because it's a problem, right? And it never got resolved. So one time I went to court as an expert, and the judge was blaming both the tenant and the landlord, blaming them for not resolving the problem. He goes, you're wasting the court's time. We don't have time to deal with this kind of Manini cases. You know what? Both of you guys get out of my courtroom and talk amongst yourselves, and then come back and I want to know what you guys settled. And everybody's going, holy mackerel, what is this? Right? And and I was in the courtroom and I heard that, and I'm like, hey, the judge is not too happy. So just be aware, you don't want to go to court. If you think that you have a good case, you don't want to go to court because it just makes things worse. It's better to settle it. And if you're a landlord or a tenant, tell the other party, hey, I don't think you want to go to court because I went on this webinar and the guy told me that the judges they're not too happy having to deal with these kind of things, right? So anyway, thank you everybody for attending. Hopefully you learned something. If you have any questions, post it on the social media platform or send us an email or some correspondence, and we'll be able to get back to you. Tune in on other webinars that we're having, and we always want to share information. So on behalf of Martin and myself, thank you for joining us, and aloha and mahalo.